In Massachusetts, we've got closing arguments expected today in the Irish firefighter rape trial for defendant Terence Crosbie. That is our top story. Now, the jury will soon be deciding his fate, and it could come down to the testimony versus the forensic science. So the jurors got to hear Crosbie's side of the story. He testified in his own defense on Tuesday. This guy's on trial for a second time here in America, even though he's a citizen of the country of Ireland. Dublin, to be precise, is where he lives. He's on trial here because he came to town to march in a parade. And during the time that he was here, he's accused of raping a woman at a Boston hotel. Now, the accuser testified earlier in the trial. He denied the allegations. Let's take a listen to some of his testimony. Here we go.
Just walking around the room, gathering her clothes and rummaging, looking for her belongings.
Did you look at her?
We're out. I couldn't, but I didn't try anyway.
Did you touch her?
I didn't.
Did you have any physical contact with her?
I didn't.
You specifically asked them, can you specify what that means exactly in the legal terms of rape? Is she saying someone pinned her down on the bed and had sex with her?
Only that.
Given you any information beyond the fact that there was a sexual assault alleged, right?
Yes.
And so it was your words, your specific words, asking if she was saying that someone pinned her down on the bed and had sex with her, right?
Yes, I asked him.
Crosbie's charged with one count of rape, and he's facing up to 20 years in prison if he's convicted. So who will the jury believe, him or his accuser? Let's bring in our legal eagles. Joining us this morning, criminal defense and civil rights attorney Casey Early, and civil attorney, also celebrity attorney. We saw him lead the case for Johnny Depp, Ben Chew. Good morning to you both. All right, so let's start with the defendant, and then we're going to work backwards in our conversation. We're going to get to the accuser. But since he was the most recent one to testify, I want to ask you both how you think he did. Casey, would you start us off, please?
Absolutely, and good morning, Julie. I do a lot of sexual battery cases, and I always say my sexual battery cases are much harder than my murder cases because the presumption is of guilt, and then you have to kind of convince the jury that our client didn't do it. And just listening to his testimony, watching his demeanor, and hearing how he's answering the questions straightforward, I have to say he did better than I expected, simply because he came across credible. And we know that this case is littered with reasonable doubt. We have the fact that the victim was inebriated, heavily intoxicated, and her truth, unfortunately, is not 100% reliable. And in cases of sexual assault, credibility is key. So in this case, it's going to boil down to the DNA, to the science. And even the science is inconclusive. When you hear this terminology of inconclusive, multiple contributors, or you cannot tell how long it got there or how it got there, that's transfer DNA. That's your reasonable doubt. So unfortunately, in this case, sometimes the alleged victim is not always the victim based on the circumstances.
Casey, thank you for all of that. Ben Chew, want to go to you next. Same question, please. How did you think this defendant fared on the stand?
Good morning, Julie. Good to be with you. I agree with Casey. I think he came across very well. He seems very straightforward. He's got the benefit of being a firefighter and a paramedic, which is it's going to be looked on favorably by the jury, that his job is to take care of people in precarious situations. I do think that clip that you showed from the cross-examination was effective in the sense that he appeared to have details that weren't related to him that were consistent with her claims. But overall, I agree with Casey that we likely are looking for at least one juror to find some reasonable doubt here, as happened in the first trial.
You're exactly right, Ben. First trial, for anybody who missed it, there was a mistrial. So this is trial number 2. The jury doesn't know that, but we know that. Thank you for the mention, Ben. So for the reasons that Ben and Casey stated, this case becomes really tough. I was just saying to my colleagues, I see why this one is at trial. I see why, because of the issues you both are raising. Let's turn to the accuser's testimony. I have a clip. This is from her direct examination. Here we go.
I woke up to somebody on top of me, inside of me, in his penis in my vagina, on top of me, telling me, you like this, he couldn't give this to you, I'll give it to you, he's a loser. I was focusing on getting out. I was focusing on getting to safety.
Okay, Casey, thinking back to the accuser on the stand, your thoughts on how she fared up there?
Well, oftentimes when we have accusers, we know that they're going to be emotional. So I usually address that in my voir dire, and I want to make sure that the jury is not swayed by emotion because it puts us at a disadvantage and it's not fair. So obviously she was very emotional, but again, she did not describe the basics, didn't know his name. And if he is completely naked, why didn't you describe any marks, whether there were tattoos or hair on his chest, just a simple. And when she was challenged on cross-examination, she just kept saying, I just want to get out of there. Well, that's not sufficient because most of my cases were won simply because the alleged victim could not describe the basic, whether or not he had hair on his chest or was a bare chest. That's something that you can remember. And then also when she's claimed that she was running out of the hotel and then later clarified, well, I walked out because the surveillance cameras did not corroborate her initial statement. So again, I know it's always hard for a victim, a true victim, to testify, to come forward. But again, in this case, it's just littered with reasonable doubt. And I would argue that in my closing argument.
And you are a defense attorney, a very good defense attorney for all those reasons you're giving us, Casey. Thank you for that. Ben Chu, I want your opinion on how you think the victim did, how she came across to the jury.
Well, Julie, I do think that the emotion really can't be blocked out of the jurors' minds, despite whatever instruction the judge gives. But I think that a jury could conclude that something traumatic happened to her that caused this, what appears to be very real emotion, but it wasn't a rape by the defendant. So I think, again, you've got reasonable doubt here and a very tragic situation.
Appreciate it, Ben. So I'm going to take the position, for the sake of our discussion, of this accuser. And I was thinking a lot about this when I woke up this morning and was preparing for the show. To go through, and I would encourage anyone who is entirely swayed by just the science, because I saw a lot of comments on social media saying, oh, no DNA, well, must be not guilty. And I want to kind of take a moment to go into law professor mode for a second here. That is not fatal to the case, and Ben and Casey know this, that testimonial evidence can be given every much the same amount of weight as scientific evidence. The jury's going to decide what amount of weight to give what based on what they're hearing, and we see really good attorneys attack science all the time. So it doesn't mean that we suddenly discount her claims because the test didn't produce what one might expect it to produce based on her account. I keep thinking, this woman, she's an attorney. She's not in civil court. She's not getting damages here, and she's putting herself through this a second time. The trauma for someone who is allegedly a victim of rape to do this again, to me, there's absolutely no way she could have made this up. No way. I believe her. That's me. And so I wanted to just kind of bring up the science and the testimony as our next talking point for Ben and Casey, because it generated a big discussion in our newsroom where I think non-lawyers may sometimes think, oh, the science must get more weight. Casey, do you ever run into that in practice?
I did, and this case reminds me of a case that I had where my client was charged of a sexual assault, and the alleged victim on the stand was absolutely emotional, but there was no other conclusive scientific evidence. So my argument to the jury was, I do believe something happened to her. What I don't believe is that my client was the one that committed this trauma against the alleged victim in this case. And I think that this is the case here. I do believe something happened, and I do believe that she was violated. What I don't believe is that the person that she's accusing is the person that committed the act, similar to my case in chief. And thankfully, my client was found not guilty because we all believe something happened. The emotion was too raw. And even when she was trying to recall what occurred on the stand, it was believable. But again, we want to know that a crime was committed, but my client wasn't the one that committed the crime.
So you're saying it's someone else is what you're thinking. This reminds you of a kind of the Saudi defense, as we call it, the some other dude did it defense that we say. Tell me if this changes your mind, Casey. I just learned about this this morning. So apparently after the incident, the parade was supposed to happen the next day, the day after the incident in question. And this guy came to America to walk in that parade. When police apprehend him at the airport, Ben, I'm going to come to you on the other side of this. Police get him at the airport and they say, "Where are you going?" You know, why are you leaving so fast? We know you were at the hotel. We know where you were staying. Why in the world did you leave so suddenly? And they get the ID because of the roommate, right? He's friends with this guy named Liam who did have the consensual sex with the accuser. And his answer is, "I saw the door open at the hotel and it frightened me. So that's why I packed up and went to take off." Ben Chu, what do you think? What do those actions say about Mr. Crosbie?
Julie, I'm so glad you raised that. I think that was really the most incriminating thing. That's not a plausible explanation for why he would cut short what obviously is a big trip for him, and his desire to go and march in the parade. For him to leave prematurely like this, he really had no explanation. You would have expected him to say, "One of my children was sick, my wife, requested that I come home because there was some crisis at home," but that wasn't the case. And so if I were the prosecution, I would hammer this home again and again and again, as with the details about the woman being pinned down, because that's something that he couldn't have possibly known unless he'd actually done it.